Good afternoon. I'm DJ O'Brien with the Brooks Pierce Law Firm. Also with me is James Bobbitt. I'm out of the Greensboro office. James is out of the Raleigh office, but we serve clients throughout North Carolina and beyond. We appreciate you joining us for navigating non-compete, non-solicitation, and confidentiality agreements. We've got about an hour of a program here, which will include about 5 to 10 minutes of questions and answers at the very end. So we encourage you to submit questions, not just at the end, but throughout the presentation if you have any. Using the chat function that should be at the bottom of your screen. After this presentation, within the next day or so, we will circulate this PowerPoint that we're using today, as well as a link to the recording, which will also be accessible through our website. Again, I'm DJ O'Brien, and with me is James Bobbitt. On this program, we're going to go through basically 4 topics: a background on non-compete law, and then James will tackle non-solicitation agreements as well as confidentiality agreements. We'll then turn to alternative approaches to these agreements, and then James will conclude with updates on non-competition agreements, non-solicitation agreements, and confidentiality agreements, particularly with the new administration in Washington. An important disclaimer, we are attorneys and we are talking about legal topics, and we hope that you find it educational. However, nothing that we are providing in here should be deemed to be considered an attorney-client privileged communication, nor is it legal advice specific to your situation. James and I and all of the labor and employment practitioners at Brooks Pierce, of course, would be happy to try to talk to you about your specific legal questions after this program. And you can contact us at the information that's in this PowerPoint that will be distributed. Also at the end, we'll have a link or information for human resources credit. Turning to non-competes and the background on them, I think most people who would sign up for this program have a familiarity with non-competes. Its basic definition, of course, is a restrictive agreement prohibiting employees from working for a competitor or otherwise competing against that former employer. The typical contract has offer and acceptance and some type of consideration. And of course, a restrictive covenant like a non-compete is a contract, but it's also something more, and it's scrutinized differently. In North Carolina, they are viewed as a restraint against trade, and so therefore they're narrowly construed by the courts. Most estimates show that around 20% of US employees are subject to some type of non-compete. So they're very prevalent, and they've been growing despite this trend toward limiting their enforcement. We're taping this and presenting this in May of 2021 as we seem to be emerging potentially from the pandemic. A year ago at this time, we were facing lots of questions from employers, including questions about non-compete agreements and whether they could enforce them. Obviously, there was tremendous layoffs in March, April, and May of last year. Millions, tens of millions of workers suddenly found themselves without jobs. And some of those workers were subject to non-competes. And the questions we were getting for both employers and employees was, can we enforce these agreements given the circumstances? And the cases are still kind of trending out there. What we did see was perhaps more scrutiny by the courts during the pandemic, given the circumstances, the unfairness of a person who's laid off through no fault of their own in a lot of cases, then being subject to restrictions on their ability to find new work when we really wanted people to get back to work if they could. And so courts were really scrutinizing it. Now, as more and more Americans are entering the workforce, despite the bad jobs numbers or disappointing jobs numbers from April, we're still getting a lot of questions from employers and employees as to what's going to be the scope of non-competes going forward. Should we require them? Will they be enforced? And we think this will be a continued area for employers to be focused on. As I mentioned, these are increasingly narrowly construed. Courts can be reluctant in the situation in which a corporation is attempting to stop somebody from working to prevent that person, that man or woman, from earning a living. That kind of difficult enforcement can change, however, if there is misconduct or bad faith by the former employee. Obviously, a departing employee who copies and forwards client lists, proprietary information to him or herself to use it to compete against the former employer is going to be looked at a little bit more skeptically. But in general, in a situation in which someone's departing and wants to work, the court is going to look very closely at that to make sure that reasonableness is met. Again, though, they continue to be narrowed in North Carolina and beyond. I should mention that state law is extremely important in terms of the choice of venue and choice of law. Obviously, a lot of corporations have offices in different places, and so the law can be different. They also can put into the restrictive covenants clauses that designate a certain choice of law. It's important to consult with an attorney, obviously, in drafting these agreements, and that might be one important consideration. James is going to talk a little bit later about some of those choice of law type issues, particularly in a pandemic, but I think also with more and more remote work, where employees may be working for a company and they may be two different locations, and it may be an interesting analysis as to which law applies. Again, North Carolina disfavors non-competition agreements. That doesn't mean they don't enforce them. They recognize them in many circumstances. Other states like California and other jurisdictions might be much more restrictive, and there can be penalties for actually trying to include it in there, even if it's not enforceable. On the last point there about not being able to have courts rewrite overly broad non-competes, I think there is a tendency for employers to want to have a very, very broad covenant that restricts people from being able to work. And that temptation is problematic for a couple of reasons. One is it's more likely to be seen as unenforceable and not paid attention to by a departing employee who may get advice from a lawyer that it's not going to be enforced. But in North Carolina, courts cannot rewrite overly broad non-competes. So, for example, if you have a non-compete that restricts somebody from working on planet Earth for the rest of time, the court is not going to come in and say, well, that's too much, but we're going to limit it to 30 miles from the company headquarters for a period of 6 months. No, it'll be struck down completely. But this is called the Blueprints rule in North Carolina, which does allow courts in North Carolina to, instead of rewriting an overly broad covenant, it can strike that one covenant, but allow other parts to continue. For example, a non-solicitation agreement or a confidentiality agreement that is otherwise enforceable. One last point I want to stress, particularly with the pandemic, this was an issue. Sometimes we get questions from employers as to whether or not if they fire an employee for cause or without cause, if they can be subject to the non-compete they signed. And the answer is yes. There is no per se rule that a fired employee can be terminated, can't be subject to a non-compete if they're terminated. Obviously, that can factor into the court's analysis. If someone who did not have misconduct but was terminated through no fault of their own, that's going to be important consideration, but there is no provision against it. On the next slide, I just want to talk about some of the context. It can come up in other contexts, but you typically see these with employees or independent contractors. We get questions from both employees and employers. And I should mention, while Brooks Pierce is often considered a defense-oriented firm, with respect to non-competes, we represent both employees and employers. We're on both sides of this issue without any conflict as to issue conflicts. But we get the question as to whether independent contractors can be subject to non-competes. Obviously, they tend to have fewer protections in their agreements with the who's hired them. But yes, they can. And you typically do see them even in a short-term agreement. It may be more difficult to enforce a non-compete against an independent contractor because of some of those equitable issues. This is a contractor who may have less protections. On the other hand, it may be easier to enforce against an independent contractor who by their definition should be able to have other business, other clients. It depends on the language in many different cases. Also, with respect to that first bullet with employees, I'm going to talk about the elements of a non-compete, and typically it's part of an employment contract and needs to be part of it. But an employment contract obviously can include a severance agreement. And so a severance agreement is a good opportunity to put in a non-compete clause as a condition of that severance. And then business transfer and purchases, you frequently see a non-competition agreement in there. Those are given greater deference with respect to non-competes if you have a business sale. The reason being, a restricted party is getting greater value as opposed to an employee who basically wants the job and may not have comparable bargaining power. So for those two factors, greater value, comparable bargaining power, you're more likely to have an enforceable non-competition agreement if you're purchasing a business and you don't want the person to walk down the street and open up, say, a competing pet store. Similarly with franchise agreements, it's very common to include non-competition agreements in those, and those are given greater deference. The reason being, a franchise agreement by its definition implies a transfer of goodwill of one company to another. And the idea being that we can have a non-competition agreement there because if someone is operating, for example, a restaurant or some other business for a number of years and then keeps the same location, keeps the same phone number, maybe even keeps very similar trademarks, which can cause other legal issues, that would impact the franchisors' economic benefit of contracting with them. Turning to the elements of a valid, enforceable non-competition agreement, at least in North Carolina, which is similar to many, many other jurisdictions. I'm going to talk about these factors. The first two are fairly simple, that it needs to be in writing. You certainly can have a contract. In other contexts in North Carolina, that is just oral. We certainly litigate those. Lawyers tend to think nothing ever happens unless there's something in writing, but that's not the case. But with respect to non-competes, it needs to be in writing. And importantly, it needs to be signed by the party that is agreeing to the restriction. It's not totally uncommon for an employer to contact us and talk about a non-competition agreement. And when we ask, can we see the actual copy as opposed to the draft that you say everybody signed, there's difficulty locating it. And that's a problem. Even if you say, well, I have everybody sign these, and so it's the same thing. No, we really need it to be in writing. So keep those signed copies for everybody. And of course, that can be done in many cases electronically. Must be part of the employment contract. And based on valuable consideration, the key factor, I think, is going to be reasonable as to time and territory, which I'll talk about briefly. And then designed to protect a legitimate business interest. I frequently tell my clients that the non-competition agreements are designed not to protect against any competition, but against certain protectable interests. You can't just stifle fair competition through these agreements. As to valuable consideration, this can be just about anything as long as it's not illusory. The common context for when this gets into be a problem is when someone has a workforce and they go to a seminar like this and they think that, well, I need to get non-competes in there, and then they just make all their employees sign them or they're going to be terminated. That's generally not going to be enforced because North Carolina, unlike some other jurisdictions, requires there be some consideration. It could be the promise of new employment, a promise of employment for a specific duration, meaning as an at-will state, employees can be fired for many different reasons unless they have a contract for a certain term. Well, if you give an employee the value of guaranteed employment for a specific duration, and it can be conditioned on certain things, that certainly is going to be sufficient consideration. Courts have held sufficient consideration to constitute something as low as $100. I do think that the lower the value of the consideration, the more the court may be scrutinizing the reasonableness of that restriction. So this is not a advice to go off and give your employees a coupon for signing a non-compete. That will be scrutinized if that's the case. As to the reasonableness, as to time and territory, this is very fact specific. It depends on your industry and your products and your customers. I frequently really enjoy digging into a non-competition agreement on the back end. I'm more of a litigator than on the front end, but I do draft these all the time. But on the back end, when there's been a potential conflict, we really have to dive into what specifically do you make. Please explain it in the dumbest terms possible to this lawyer who is not familiar with your industry so I can understand it, because the facts are really, really going to matter. It has to be reasonable as to time and territory. They're considered in tandem. meaning you don't just in isolation say 2 years is fine when the restriction is for the entire world. You have to consider both of them. In practice, I tend to see the courts looking more at the territorial restrictions because most people, as the cases have developed, have kind of fallen into the concept that somewhere around 2 years is going to be presumptively okay. Not absolutely, because you could still have an overly broad geographic restriction, but 2 years is what we often see. 3 years is out on the outer scope. There have been restrictions of 5 or 10 years that have been upheld. I think the 10-year has mostly been considered to be patently unreasonable, that you're never going to get a 10-year agreement absent very interesting circumstances. So normally the 2-year is where you're looking at protectable interest. But again, it's very fact specific, and it'll need to be not something that's just grabbed and stuck in there, but thought through carefully as to what you'll protect. As to the next slide and territory, in consideration at the same time as the time, the main concept I would take away is that it's very difficult to restrict an employee from working outside of the context where either the employee actually worked, where he was servicing clients, he or she was servicing clients, or actually physically worked, or maybe even a little bit broader, where the company does business. A frequent challenge to non-competes is to say, this says you can't work in the United States in these 3 countries after the employment, but you don't even do business in 2 of those countries. So why would you restrict it there? And this employee never did business there. And that's where you might have a little bit more difficulty enforcing it. I've got the factors up here as to what will be considered as to the territory. I think that to show reasonableness, the main focus needs to be the location of your customers, the extent of the business there, and why the scope is necessary. On the front end, in a non-compete, you may not know all of your customers or all of your regions. And so you don't have to name that with specificity. Obviously, if you can and feel confident that that'll be the same for 2 years, that may be more likely to be upheld, but we frequently have non-competition agreements that limit the scope to a radius where the employee worked or particular customers, and with a look back period of maybe 6 to 12 months for people they worked on. But there's a lot of litigation over this issue. As to customer-based restrictions on the next slide, this can be a substitute for geographic restriction. It's really analyzed in the same way so as to not be overly broad. Again, it really needs to be limited to actual customer contacts, not just existing, but potential. There's a lot of non-competition agreements with sales executives, and so they are constantly meeting people, constantly pitching business. That could be litigated too if you're at a sales conference and are talking to somebody. Is that a potential client, or is a potential client something a little bit more where there's actual proposals being made? There can be exceptions to have more broad restrictions for senior executives, people at the very top of a business that may touch on all aspects of the business. In those circumstances, it may be appropriate to have a non-competition agreement that's broader than what you normally see. On the next slide, as to protecting a legitimate business interest, again, the idea is to have protection against unfair competition. I don't mean that somebody is stealing from you necessarily, but someone who has gained a valuable source of information, proprietary knowledge, skill, training, and it's reasonable to not have them immediately, having received the benefit of all that training and skill, turn around and compete. It's got to be something legitimate and protectable, such as proprietary information, client information, and there can be other obviously valuable information depending on your industry. As to direct versus indirect competition, as you might expect, that non-competition agreements are harder to enforce when the restricted competition is more indirect, meaning it's in a related field, but you're not exactly competing against each other. So why are we restricting this person who was with the software company to go work for another software company in a different area that services different clients, even if by the terms of the non-compete, they tend to reach the same area? And I would also say you can have a totally legitimate interest that cannot be protected in an unreasonable manner, meaning you go too far toward protecting somebody against competition. James is going to have a slide later on as to the remedies for a breach of a non-compete, as to kind of the anatomy of how a lawsuit would entail for non-competition litigation. But obviously, one thing you should always be asking your lawyer anytime you're considering enforcing an agreement is, what are you looking for? What are you trying to accomplish? Non-competition agreements are typically enforced through injunctive release. That means there can be a temporary restraining order or a preliminary injunction. Those happen at the very first part of a lawsuit that can make the lawsuit very front-loaded, because if you win on that early question as to whether or not you've got something to protect, the person may not be able to go work for the job. The new employer may want to move on. The client may be preserved. So a lot of that happens at the front end. But you may also be looking for money damages. It's a breach of a contract. There can be lost profits, lost business, diverted opportunities. We sometimes draft non-competition agreements, employment agreements that have liquidated damages clause, in which that's a clause that says, my damages are difficult to ascertain if this person violates this agreement. So therefore, we both agree that if there is a violation and I prove there's a breach, I will be entitled to liquidated damages in a certain amount of $5,000 or $10,000. That's going to be scrutinized the same way to make sure it's reasonable. And they're harder to have enforced, but they can be enforced even in the non-competition agreements. Oftentimes, too, we'll seek an extended restrictive period. If an employee breaches their non-competition agreement, one of the remedies we'll ask for is to say, Judge, it's reasonable to extend this by an additional 6 months because we've had to go forward and enforce this agreement. And increasingly, you'll see claims for attorney's fees. In North Carolina, the presumption is everybody bears their own costs, unless there's some contract or other indicator that we're going to have fee shifting. And it's not uncommon to have an indemnification clause or a clause that says that if you breach this agreement, then I'm going to be entitled to attorney's fees. There are some certain special employment contexts in which non-competition agreements are governed by different rules. And I don't know if this touches on anybody who's attending this. We appreciate, by the way, the tremendous attendance for today's webinar. But attorneys and physicians are subject to these agreements or to more restrictions on non-competition agreements, with the idea being, as to public policy in North Carolina, not wanting for people with these degrees, these skills to be limited in servicing clients. For example, a physician may be the only particular type of physician that does something in a certain area. My grandfather was the only orthopedic surgeon between Birmingham and Nashville for 30 years. For example, if he was subject to a non-compete and tried to move on, who's going to fix their bones? So that's where the court will scrutinize it. On the other hand, if you've got a general dentistry practice, that's going to be less perhaps to worry about, because there's lots of different dentists around. There may be more access to that, so it may be hard to protect that. Financial investment advisors are governed by FINRA. I think it's Rule 2140. Difficult to have non-competition agreements in that context. Certainly with securities law, you should consult with an attorney. And interestingly, locksmiths in North Carolina have some more prohibition on non-competition agreements. I've not litigated that. I think it's the idea that if a locksmith comes in and puts a new bolt on your door, that maybe he or she's got more power over you. I'm going to turn it over to James here in a second, but just lastly, before I return back to you, in the pandemic, we're seeing some interest. It's upended life everywhere, and it's upended the legal world in many ways. As I said, we saw greater scrutiny of non-competition agreements when there was such massive unemployment and people were in tough circumstances. Now we're starting to see those questions about, well, how is it going to change things? And I think that the world around us, it will be always very, very relevant. Do we need people to get back to work? Do we have a weak job market? Is there a lot of competition out there? What type of services are you providing? Do we really want to restrict, people who are involved in the medical field during something like this? And then I think just kind of finally, there were a lot of contracts that just did not anticipate a pandemic. And we looked at force majeure clauses that just never saw a pandemic coming. And there's open questions as to how that would be enforced. With that, I'll turn it over to James to talk about a related concept of non-solicitation agreements.
Thanks, DJ, and thanks everyone for being with us today. I'm going to talk briefly about non-solicitation agreements and or confidentiality or non-disclosure agreements. And so first, non-solicitation agreements. What these agreements really go to the heart of is making sure that in situations where employees leave your company, leave your business, that they aren't then allowed to go compete with you, but go compete with you in a very specific way. And that way is try to take your customers, your clients, your suppliers, in some situations, your current employees who really they gained access to knowledge of and really built relationships with on behalf of you while they were employed with you. And so these agreements really go to trying to prevent, for lack of a better word, the pirating of resources from your business to a competitor. So in North Carolina, these non-solicitation agreements are treated much like geographic-based non-compete agreements, like DJ talked about some earlier. Really what that comes down to, and really what the best practice would be, is to limit these non-solicitation agreements to customers, clients that former employees had contact with. And so, if your former employee was a sales rep for North Carolina, may not make sense to have him be prohibited from soliciting customers that were in Georgia. If he never went to Georgia, never had contacts with those customers in Georgia. And so you really want to try to limit that, because if these are too broad, once again, that's a situation where a court may step in and say, you tried to do too much, and therefore the agreement itself fails. With that being said, as DJ brought up, enforcement does vary by jurisdiction. And so you really want to make sure that you're looking at the laws in the places where you do business, where you employ people. One thing I wanted to do with y'all today is kind of walk you through some sample language. And so I've taken some language from SHRM. And this presentation today is being offered for SHRM credit. And so those of you who are familiar know that SHRM is a wonderful, wonderful resource for human resource professionals. And they offer really good content. And so here is a sample non-solicitation, and this one relates to customers and clients. And so I'll give you a second to look at that. And then I'm going to highlight on a few things that are in here that I think that are important to point out. So first, you'll see here at the top, the period of time that these are good for. Once again, DJ kind of talked about this. Typically, the shorter, the smaller in scope, the more enforceable, the larger in scope, the longer the period. Courts have a harder time finding those enforceable. The next thing I want to point out is this language here about directly or indirectly solicit. And so a lot of times it's the case where we have situations where former employees, they leave our client, they leave the business that they've worked for these number of years with all the knowledge of the inner workings of that business, that proprietary information, and they understand that they are subject to a non-compete, a non-solicitation agreement. And so what they will try to do is solicit business by proxy. They'll give their knowledge to someone, typically someone at their new employer, as a way to try to work around the non-compete covenants and non-solicitation agreements that they've signed. This language is in here to specifically thwart that. And so by saying that, you can't use a third party to try to circumvent this, that is essentially the same as you soliciting those customers, those clients, and that's not allowed. The next thing I want to point out here is talk about services, and DJ talked about this, but and here's an example. If you employ someone who is a janitor and perhaps they have a non-compete in some agreement that they've signed with you, you may not be able to prevent them from going to work as a salesman with a company, perhaps that you do, that's a direct competitor of yours. if at your company as a janitor, they didn't learn anything or do anything that would allow them to have knowledge of your inner workings. And so really looking at, well, exactly how and in which ways are we trying to limit this former employee's conduct, behavior, employability after he leaves or she leaves our business. Substantial dealings is another thing I want to point on. And so here goes that language right here. And really what that comes down to is, and DJ talked about this, but structuring the non-solicitation agreements so that the employees who are subject to these, former employees that are subject to these after leaving, that the restrictions are tied in some way to customers that they had contact with. And so one common way of doing that is to include a look back period. And so say, hey, your employment with us ended on X date. For 12 months before X date, any customer, any client that you had contact with, and whether that be you serviced them in some way, if you're a salesperson, or perhaps you pitched business to them in a meaningful way, we're going to ask that you not do business with those clients for X period moving forward when you get to your new employer. And so really all of this language in here and language that I've just gone through with you is in here for very specific reasons. I've kind of pulled back the curtain a little bit as to what attorneys do for those of you who are not attorneys on the call, but we would also recommend that, of course, that anytime you're looking to implement one of these agreements, one of these non-solicitation covenants, that you consult legal counsel. Moving forward for a second, or moving on to employees, I should say, a lot of times you will see situations where employers want to protect their own employees from being taken by former employees as they are on their way out the door to either go to competitors, or a lot of times what we'll see is to start their own business. And so some people may call these anti-poaching agreements. There's a variety of names for them, but in situations where you think that your business model may be particularly at risk for employees leaving and wanting to take people that you've trained with them, this may be one type of an agreement that you can adopt to try to limit that risk. Moving on to confidentiality and non-disclosure agreements, commonly referred to as NDAs. These agreements really get to trying to protect that invaluable knowledge that you instill in your employees during their employment with the company. And so what are those, for lack of a better way of putting it, everything that you've taught them about how to work in the position, all the training perhaps that you've given them access to, the confidential information, trying to make sure that there's some safeguard so that they can't then use that knowledge to compete against you. Really important in drafting these, you want to make sure that they aren't overly broad for a lot of the reasons we've stated, but also because courts will invalidate these agreements if they once again think that employers are doing too much, if they're overreaching. A lot of times what we'll see is we really want our clients to specify what those things are that they think are valuable at their company, whether that be client lists, customer lists, certain, if you're a salesperson, certain account information, whether it be quotes that you're providing to employees or certain pricing information that you're providing to employees or they have access to as a result of being in your employ. You want to specify all that. You want to say that these are the things that are valuable at my company. This also can cover some trade secrets, which is not the focus of today's presentation, but it's something that comes with its own set of issues and and legal things surrounding it that you'll definitely want to consult counsel about. And once again, both the non-solicitation and non-disclosure agreements, to go to this last point, are often used in tandem with non-competes to try to protect this information. I also want to point out that a lot of times employers will enter into non-competes, or not non-competes, but non-disclosure agreements sometime after the employment relationship has already been established, so not at the outset of employment. We see that a lot because I think clients realize that somewhere down the road that they have this information that's worth protecting. Of course, it would be a best practice to incorporate these at the outset when you're putting, your non-competes, your non-solicitation agreements in that employment contract at the beginning of employment. But to the extent that you're going to do this down the road, there's actually kind of a split in North Carolina amongst the courts as to whether or not these contracts require additional consideration, so additional payment or value of some sort. And so it's a best practice to just probably treat them as such, treat them as requiring new consideration. But once again, if you're interested in doing that, I would recommend that you consult with legal counsel so that you're able to get advice on the specifics of your situation. I have some more language here taken from SHRM that shows examples of kind of what these agreements look like. Really, the big thing here is going to be that both current and former employees can be subject to non-disclosure agreements. That's worth pointing out. So during the course of employment, you may want to prevent people from disclosing certain things to others outside the company. And so that can be in here. But also this term confidential information, which I'm actually going to talk about on the next slide, is really important because once again, you don't want to be too broad. You really want to specify what it is that you're seeking to protect. And so here, as you can see in this second bullet, in this agreement, the drafter has gone about making sure that specific things are in there: technical designs, data dictionaries, financial information. With that being said, there's some things that you can't protect. And so, things that the employee may have already been aware of prior to joining your company, things that end up in the public domain. This is a big one, especially as it relates to trade secrets. Any of you who have done work in that arena know that the concept of reverse engineering oftentimes undermines a trade secret. So to the extent someone can figure out through their own devices the things that you are claiming are secret, those things won't be deemed secret by the court. So with that, I'm going to turn it back over to DJ, who's going to talk about kind of how you can use these things in different ways to protect the information that you may have.
Thanks, James. As described, I think the non-compete agreements are more difficult to enforce than the non-solicitation and confidentiality agreements. But as James explained, those can have their own problems to be protected. So I think non-competes are a little bit more difficult to enforce. So I've always encouraged employers to consider whether or not they really need to keep their focus on the confidentiality and non-solicitation components of an agreement. And those are alternatives to protecting those interests. And of course, as I mentioned, under North Carolina law, if you've got an overly broad non-competition agreement that may be struck, but you still can fall back if properly drafted on a non-compete on a non-solicitation or a confidentiality agreement that's otherwise enforceable. That's very, very common for all three of those provisions or more to be part of litigation when they're trying to be enforced. But as non-competition agreements have become more difficult to enforce, and James in a second is going to talk about how there's legislative approaches and other scrutiny of these agreements, some just outright outlawing them. There's also courts that are narrowly construing them. I think we're increasingly looking at alternatives Usually these alternatives require more consideration, more money given to the employee. But that's part of the undue burden analysis, meaning that when a court is deciding whether or not to enforce a non-compete agreement against a person looking for a job who wants to take a new job, the burden on that employee is one thing the court will look at. The other reason I think we're looking at alternative approaches is that even if you've got a terrific non-competition agreement, again, you may have a skeptical judge. There's also, as no attorney ethically can guarantee an outcome, and there's just no guarantees in litigation as to what a judge or a jury might do. So you're looking at the situation in which you draft a non-competition agreement and then have to enforce it, and are trying to make the decision, well, if I file a lawsuit, I have to pay a lawyer. I'm not sure if I'll actually win, and it's going to be costly. And am I actually going to achieve anything worthwhile? Am I going to keep that customer that I'm worried about being poached from me if I'm filing a lawsuit against, for example, their new employee? So all those have to be carefully considered, which is why you look at alternative approaches. These approaches with respect to the second, third, and fourth bullet points, I would say have yet to really achieve the same popularity as non-competition agreements. Non-disclosure, non-solicitation agreements are very, very common. A garden leave period is a situation in which an employee is required to give notice of a certain amount of time before leaving. And if they do that, they still get their salary or some other valuable consideration in the form of money. That has two advantages. If the employee during that period, when they've said they're going to leave, their garden leave period, fails to abide by a covenant not to compete for that time period, it's not only a breach of contract, it's also a breach of the duty of loyalty, and it may be more enforceable. And again, this is an employee who's being paid for this period in which they're restricted. I recently had a person consult with me about a non-competition agreement, and it was for a period of time in which this person was going to be receiving severance. And so that's a very good chance that's going to be enforceable, because they had a choice. They can keep taking the severance, or they can choose to compete with the company. And that may not be enough of protection for the employer, but it is an option that's very likely to be upheld, because what can the employee say? If they want to take this opportunity, they've got a choice as to forfeiting their severance pay. Safety net payments are fairly similar to a garden leave period. It usually, though, applies after an employee is leaving, not for a period of time in which they may still be around. And that is where an employee agrees to certain conditions after they leave. They agree not to compete, and they also get some type of safety net. You're essentially buying the employee to not compete against you. And because of that payment, I think a court is going to deem it, fairly good consideration, and therefore likely to be held. We talked about a little bit about client purchase agreements and those given more deference. And the reason for that is because if you're subjecting yourself to a restrictive covenant and selling your business, you're getting something of greater value. You presumably, but not necessarily, have comparable bargaining power. And so therefore, it's a situation in which the court is more likely to allow a restricted period of time for the employee to be subject to a non-competition agreement. The thing I would also add to James's presentation as to confidentiality, even if you don't have a non-competition agreement or a confidentiality agreement, there still is in North Carolina law the concept of the breach of a duty of loyalty or the breach of the duty of fair dealing, meaning that even if an employee is not subject to a confidentiality agreement, or perhaps it's written in a way that's unfortunate and not enforceable, that doesn't mean they can take certain steps. Obviously, you would like to have a contract that gives you something to fall back on to protect those interests, but there still is the concept that there's a common law protection against an employee breaching a duty of loyalty by going against his or her employer. And I'll turn it back to James to talk about some of the very, very recent trends that are emerging in the areas of non-competitions, non-solicitation, and confidentiality agreements.
Thanks, DJ. And before we get there, one thing I did want to touch on just really briefly, and we kind of talked about it already, was really you have a non-compete, you have an employee who you think is breaching the non-compete, now what? Really how this works and kind of what this looks like is you send them a letter, you send them a cease and desist letter. You say, hey, we found out that you're competing against us, you're subject to this agreement, you need to stop. That's the first step. And hopefully, and really hopefully, because the next of this, these next steps can be quite costly and quite lengthy. Hopefully after that, the employee stops. But in the event they do not, oftentimes employers have to proceed to filing a lawsuit. And so what that looks like is just filing, of course, the necessary summons and complaint, but also with that, if the situation warrants it, filing a TRO. A TRO is a temporary restraining order. It's basically a short-term temporary injunction. And what a temporary injunction is, or an injunction is generally, is an order from the court commanding someone to do something, not to do something, refrain from doing something. So in this situation, it would be ordering someone to stop breaching their agreement with their employer in X, Y, or Z way. This happens really quickly at the outset of a lawsuit. And so it is very common for our clients who are employers to have to spend a lot of money up front. This can be a very costly, very quickly costly process. After the TRO stage, and I'll also point out that the TRO and also the preliminary injunction that I'll talk about in a little bit typically require a hearing of some sort for you to actually go to court, present arguments to a judge, and the judge make a determination. But assuming a TRO is kind of entered, in your case, what we would then do is that there'd be some period of discovery. And for those of you who are familiar with litigation, know that discovery is really the place, the opportunity for the parties to exchange all relevant information, documents, interviews, everything related to a specific matter. Discovery is actually another place where things can get costly quite quickly with the world that we live in now, which is to say with the access that we have to the internet and electronic communications. What I've seen recently is that it can be very costly to hire a forensic expert, which is often necessary to come in and see, certain information, for example, that you're claiming a former employee took. Well, what did they then do with that information? Who's seen it? Who has access to it? How have they used it? That oftentimes will now necessitate hiring someone to come in and analyze both personal and work devices, which can be a lot of money, quite frankly. After the TRO is entered, there may be some period of limited discovery, and then ultimately a preliminary injunction. And a preliminary injunction is, once again, the court saying to either do or not do something. And in this situation, for the preliminary injunction, it would be saying that the former employee has to do or refrain from doing the anti-competitive behavior for the duration of the lawsuit. What then happens is that the litigation progresses and eventually you get to a permanent injunction, meaning that the court determines that the relief that the employer is asking for, the employee to adhere to the provisions of the contract that were signed, that the judge will say, you employee have to honor what you signed, the bargain that you made, and not compete in this specific way for X amount of time. Oftentimes, you also see that these things are appealed, meaning that due to some issue or finding that happened in the entire process before this, that you ask that the parties ask that a second look be taken at it, kind of all the proceedings that happened and the decision that was made. And so this can be not only an expensive, but a lengthy process. And that's why DJ's prior slide about what are the alternatives is important, because it may be the situation where you can accomplish your goals without having a formal non-compete dispute that results in litigation. I do want to talk now just about some important updates that we've seen in this arena. The first is really, it is a big deal. We don't know ultimately if anything will come of it, but the Biden administration disfavors non-competes. When President Biden was running for office, his website contained these broad kind of policy statements and kind of positions on what he views or how he views non-competes. And so really clearly you can see that in this last bullet point, he wants to introduce federal legislation that would kind of get rid of non-competes. And that's the simplest way to put it. And I think that is what the objective would be. So far, we haven't seen any movement on this, but if there is movement taken on this, it would be a big deal. The next update that I want to touch on, because this is a state issue, at least currently, various states do various things. There's no one uniform approach out there. And a lot of states now are taking the position that they don't like non-competes. California for a long time has been one of the ones, or I should say leaders in this push. But dealing with our slice of the country over here, you have to go now no further than Virginia, Maryland, and DC, which are all, I live in Raleigh, a 4-hour drive from me, to see some very real ways in which non-compete law is changing. In Virginia and Maryland, specifically, there's been pushes to get rid of these agreements for low-wage workers, and some of the rationale there is that these individuals aren't doing the type of skilled labor that some would argue non-competes are really geared to or best able to protect. Or I should rephrase that, where some people think that non-competes should only be used to protect those very highly skilled and highly compensated employees. And so, for instance, if someone's working an entry-level job here, there's no reason they shouldn't be able to work an entry-level job somewhere else. DC has actually introduced an even stricter ban, which would get rid of all non-competes. That hasn't gone into effect yet, but definitely something to keep an eye on. This is also really important in the context of COVID and what I think will be the new post-COVID world, which is people are going to want to work remotely. People are going to want to work, from wherever. This is definitely one of the things that you should keep in mind for your company, because depending on where an employee is physically located at the time they enter into these contracts, depending on what law applies, you may find yourself in situations where your non-compete agreement, your non-solicitation, your confidentiality agreement, perhaps they don't apply. Perhaps they can't be legally enforced. You may also find situations in which the court is just going to enforce it differently than it would in other jurisdictions. And so definitely keep this in mind as you're both working with counsel to draft these agreements and then also trying to enforce them. And so with that said, we would like to open the floor up for questions.
James, I would just add, while waiting to see if there are any questions in the chat box, and we encourage you to please submit any questions you might have on this. It does seem that in the employment context and politically, it can make a difference as to who's in power with, for example, the Obama administration and now the Biden administration wanting to have fewer independent contractors for those individuals to have the protections as employees. And then with the Trump administration, where they made it much, much easier to have independent contractors. This is different in the non-competition agreement. I think the states that James was talking about that were enacting new programs, they tended to be maybe blue states, but I think there's a lot of bipartisan support for the concept of not having non-competition agreements be too broad. And with the concept being, of course, on the Republican side, perhaps the freedom of employment, people being able to choose to make a living. On the Democratic side, just the idea that, very similarly, that we're not going to let employers restrict people from quitting or even being terminated and not being able to work. So I do think it's very, very possible you're going to see more movement in this area, although the concept of a federal ban on non-competes is probably a little bit out of reach for now, and you're more likely to see state by state action on that. And again, there's been some abuses, particularly with respect to non-competes. The concept of Jimmy John's, for example, in Illinois and New York City, requiring its sandwich makers to be subject to non-competes, not be able to go work within a 3-mile radius for a restaurant that had 10% of its sales derived from subs or other sandwiches. You know, is that something that Jimmy John's really needs to be protecting? And they reached a settlement that took care of that issue. And so I think it's issues like that, but also some more stuff that does not make the news that has led to some of the skepticism about non-competes. So we're happy to take your questions. We only have a minute or two left. And if there are none, we certainly appreciate your time today listening to us. And we're obviously here at Brooks Pierce with our colleagues, ready and able to help you with your employment needs.